My name is Kiza Koya, and I'm here to present the legal liabilities of the music industry, which is part of the entertainment business. In every industry, there are many, many legal risks and factors to think of, and in the entertainment business, it is no different. And it's important to seek legal advice and prepare prior to encountering trouble. So I'm going to start with a very different, I think, controversy. And the reason I decided to talk about this one is because it impacts me and my brand directly. Um, and I know most of the time music law is focused on copyright, trademark, and licensing, but part of it is also centered in the legalities and requirements that artists and brands may need to run their business, for example, perform. Um, when an artist enters a country to perform, they're usually required specific visas, and they may encounter problems if they decide to just go to the country instead of getting that paperwork done prior. So this is an example of something that happened in the US in 2017. The band Soviet arrived in Seattle for a festival, but they also planned on doing multiple shows besides that one, and they had entered the country with a visa waiver program, which ESTA is really only allowed for tourism, and it's from specific countries. There's policies and regulations set in place for performing artists to be able to enter the US and perform at festivals and tours, especially when they're getting paid. However, this band talked about the fact that they weren't getting paid, and so it wouldn't make sense for them to be deported. However, they planned on staying longer and working on multiple shows, and for that reason, they were denied entry. Artists are not allowed to work while they stay in the US in a tourist-based visa, and for that, they would need a work visa even if they weren't getting paid. However, this can be an exceptionally hard thing to achieve, even more so for emerging acts, since the O and P visas are for artists that have extraordinary ability. Um, they have achieved that already. And this is also something that can happen to other artists performing in other countries. For example, they're American artists going to Australia to perform. They also need a work visa for that. And then going into the second controversy in case. So this is fair use versus sampling without a license. Music that has been copyrighted cannot be sampled without permission and necessary licenses to be used in other artwork by persons who do not own it. However, artists still try their luck and participate in unlawful actions by sampling work illegally and making it part of their own works. Actions are as criminal and can lead to legal fees and jail time. And some artists will try to do this and say it's fair use, when fair use is actually for other purposes, such as criticizing work, parodies, or educational purposes. Nicki Minaj pays $450,000 to Tracy Chapman for sampling without permission or licenses. Minaj had asked multiple times for permission to utilize Chapman's 1988 song "Baby Can I Hold You," but was unable to get a license. And even after finishing the song "Sorry" in 2018, she was not able to get a license. So there was a case that Chapman filed against Minaj for infringement because she created and distributed derivative work based on the composition of her work. The way the case played out affected the fact that the work was never actually distributed. So Minaj left it out of the album and never officially published it, but the song was leaked and broadcast by a DJ. So the ruling of the case was a partial summary judgment in Minaj's favor because she never actually published the song. but Minaj and Chapman settled for $450 with costs and legal fees. And the last case in this presentation is musical works copyright. It's going to be Taylor Swift. When artists register a body of work with the United States Patent and Trademark Office, they register individual parts of the artwork separately so that they can defend them individually. An example of this is music lyrics and melodies. They can be registered and protected under copyright law. An artist that uses someone else's lyrics can get serious legal consequences, and so it's important to avoid. Taylor Swift is accused of stealing the lyrics of her song Shake It Off. The case was filed by Sean Hall and Nathan Butler over Players Gonna Play, a 2000 song with the lyrics Players Gonna Play and Haters Gonna Hate, which are also used by Taylor Swift's song Shake It Off. Swift's lawyers tried to get the case dismissed, but the jury had decided there was enough similarity evidence to go to court. And that was in 2021. Another year later, the case was dropped without much fuss. Not a lot was said, and Swift's team did not want to comment on any settlements, although it is possible there was one, since they did not want to answer any commentary. And regardless of the result of this case, copying another artist's work is an unlawful act and an offense that can have serious legal consequences and must be avoided at all costs. These are my references.